Hi, everyone. Welcome to HILSC's Employment Rights and Resources for Immigrants under COVID-19 webinar. Today, we are privileged to have with us Jessica Lorena Rangel from Fe Justicia Worker Center and Jordan Rydstrom-Emmert with Equal Justice Center. And I am Andrea Guten, the Legal Director for the Houston Immigration Legal Services Collaborative. For those of you who just joined, please keep yourselves on mute. You are welcome to have your video on or off, whatever's more comfortable for you. If you have questions at any time in the presentation, please enter them into the chat box and feel free to answer other folks' questions or share resources if you'd like. And if you have any tech issues, feel free to message me privately through the chat and we'll see what we can resolve. So I will let you all take it away. Jessica.
Yeah, thank you so much, Andrea. My name is Jessica Lorena Rangel. Obviously, I'm with the Fe Justicia Worker Center. We are a nonprofit organization that is based on labor law and also touches upon immigration. We realized very shortly when we opened up our centers that we cannot speak about labor law without touching up on immigration as well. They kind of go hand in hand. And not only that, but we realized that labor law can really affect everyone despite what industry they are in. So it's very, very important that we start asking ourselves these questions because we never know who is going to be in need of this information. So like the first question that we were talking about, and I'll hand it over to Jordan in a bit, is like, what are immigrants eligible for under this Corona virus aid, Relief and Economic Security CARES Act? It's really, really important. These are questions that we have been getting over and over again. And obviously, like I said, although it's a labor question right now, it also comes down to immigration as well. So I can go ahead and let Jordan kind of take it away from there.
Sure. So if we're generally, I guess I'll introduce myself first. My name is Jordan Emmert, and I'm a staff attorney here at the Equal Justice Center. And of course, since the CARES Act came into effect, we at the Equal Justice Center, along with our partners, several of whom are HILSC members, such as Workers Defense Project, TRALA, Lone Star, we've been putting our heads together trying to make sense of this law and trying to figure out what it means, what rights are permitted. And so just generally for those who maybe don't understand, Congress passed the Families First Coronavirus Response Act in the spring. The president signed it into law March 18th, 2020. It became effective on April 1st, and it contained several really important paid leave provisions related to the pandemic. But with the passing of the CARES Act, which the president signed to law on March 27th, it made several amendments and just made even greater leave provisions for the general public. And so we're going to talk about some of those provisions, some about what they need, and then we're going to do some questions. So I think the first part of the CARES Act that we're going to discuss has to do with sick and family leave. So the first provision is the Families First Coronavirus Response Act, which deals with emergency paid sick leave. And this provision provides 2 work weeks or 10 days of job protected, immediately available paid sick days for COVID-19 specific related medical and caregiver needs. It can be extended through, or it can be used up until December 2020. And it's available for eligible employees who are working at a company or organization that has less than 500 employees. Now, what's an eligible employee? They have to have been meeting one of the basic requirements set out in the law, meaning that they have to actually be impacted by COVID-19 in some form or fashion. Either they're under a local or federal or state quarantine, isolation, shelter in place, stay-at-home order. They are experiencing symptoms of COVID-19. They're caring for someone who's subject to a quarantine, caring for a child whose schools have been closed, or any other potential COVID-19 specific related issue. And so the emergency paid sick leave is available to all of those eligible employees, regardless of immigration status. And it's going to be provided to you at your average hourly rate of pay. And it's going to be provided in the same way that your normal paycheck, pay stub, direct deposit would be. If you are talking to a potential client who may be dealing with, hey, my employer's not giving me this paid sick leave even though I was sick or a family member was sick, the best remedy is going to be to contact the Wage and Hour Division of the U.S. Department of Labor, and we can provide a little bit more information about that agency moving further on. And so continuing on that, we are going to talk about the Emergency Family Medical Leave Expansion Act. This is basically an expansion of general FMLA. And this provides, it's limited for companies between 50 and 500 employees, and it provides 12 weeks of job protected unpaid leave, generally paid leave for those who are unable to work because of caring for a child or a family member who is incapacitated and needs that care due to a school, childcare, daycare, adult facility closing. However, those first 10 days, so the first 2 weeks, can be unpaid. The rest of the time is generally going to be paid at around 66% of your regular pay, but that will be based on what kind of job you have, how long you've been working there. And again, that leave is available through December 2020. You can take it sporadically. You don't have to use the 12 weeks all at once. But some of the requirements that are different than your typical FMLA leave is you have to have been working with that employer for at least 30 days, which some other regulations for typical FMLA leave require that you have been working there for a year or a different time period. So this, you just have to have been working there 30 days. Again, no restrictions when it comes to immigration status. You are eligible for this type of leave. However, if you're working at an organization or a company that has fewer than 50 employees and you know, letting all of their workers take off and to take this leave to care for children where it could impact their business or could impact their revenue, there's a possibility that those employees may not be eligible. So moving on, and I know I'm moving kind of fast on these, and we're going to have these slides available for everyone, and we'll be taking questions afterwards, but there's a lot of information and we want to make sure that we can get as much to you as possible. Let's talk a little bit about job security, and we'll talk about some of these questions and answer them a little bit more in detail later on. But one of the major things to consider is under these paid leave protection laws and the Emergency Family Medical Leave Act is COVID-19 can potentially be considered a serious health condition. And so it could receive that type of categorization if it requires inpatient treatment, being hospitalized more than a day, you know, you're there overnight, or you're incapacitated, can't work, can't go to school, can't do your normal activities, usually for 3 days or more, and you're under treatment by a healthcare professional. And so when we're dealing or talking about potential job security, keep that in mind. Can I get fired if I get sick or get diagnosed with COVID-19? Under the general FMLA, an employer can't fire you for a serious health condition. So when we're talking about COVID-19, if it has been designated as a serious health condition, you know, you're out of work, you have no energy, you are sick, you cannot leave your house, then you have a little bit of protection there. In that, again, under the FMLA, you would be eligible to take that time off, and you would have that job security. Regular FMLA, like we said, you would normally have to be working there for a year or more. But under the Emergency Paid Sick Leave and the Emergency Family Medical Leave Expansion Act, minimum is going to be 30 days of employment there. For the Emergency Paid Sick Leave, you have that job protection for up to those 10 days that you take off, as long as it's related to COVID-19. It can't just be the flu, can't just be strep throat. It has to be COVID-19 related to be able to take that leave and to have that job protection. And again, under the emergency FMLA expansion, you have those 12 weeks of protected leave. The first 10 days can be unpaid. And again, like I mentioned in the former slide, not necessarily going to have that guaranteed job protection if it's a small company and everybody's taking off. So moving on, let's talk about unemployment. I know a lot of you have probably had clients who have been asking, hey, am I eligible? What can I do about this? So let's talk about general unemployment insurance. Generally, in the state of Texas, in order to obtain unemployment, you have to be a full-time employee. You have to have received a minimum amount of wages with that employer during the last 12 to 18 months. And you have to have been working there and receiving that wage during the base period for the unemployment claim. And you have to, if you are an immigrant, you have to be documented in that you have to have a valid employment authorization. So you have to, either be seeking asylum and have an asylum application in place. You have to have gotten your valid EAD to be able to obtain the unemployment benefits. And generally, if you do not have a valid EAD, you don't have the Social Security number, then unfortunately you're not going to be eligible for unemployment, as well as if you are not a full-time employee. So if you have generally non-COVID related, you have an EAD, but you're not a full-time employee, then generally you would not be able to get that protection and get those benefits. But here's where the COVID-19 benefits are going to come into play. Under the CARES Act, there is what's known as the Pandemic Unemployment Assistance, which means that it's expanded to indicate that you are now potentially eligible to receive unemployment benefits with a valid EAD, even if you are a part-time worker, gig worker, you have not been there the general 12 to 18 month time period. That pandemic assistance really opens up a whole world of opportunity for people who normally would not have been eligible for those benefits. And the pandemic assistance also extends the usual unemployment benefits, provides an additional $600 up until July. So next month would be the last month that workers could obtain that additional financing. And so you don't have to prove your work history in the same way. What will happen though is as long as you meet one of the COVID-related qualifiers, such as your employer closed as a result of COVID, you're at home, your hours have been cut because of fewer, not as much business at your employer, or there's some sort of stay-at-home order, as long as you meet one of those qualifiers, then the big issue is going to be that most likely you'll have to apply for regular unemployment insurance benefits, you'll get denied, and then you have to apply for the pandemic assistance. So it's going to be a two-step process where you'll probably get initially denied if you normally wouldn't qualify for unemployment benefits, and then you can apply for the pandemic assistance.
Jordan, that's really helpful to know, because I think a lot of our clients, once they get the rejection, they don't do the next thing. We saw that a lot with FEMA applications after the hurricane, that like FEMA was like, oh, we always deny the first ones. And it's like, well, a lot of people don't apply again the second time. Yeah. So really key to tell your clients.
And also, if you're not seeking the pandemic assistance, but you are generally just seeking unemployment and you would be normally eligible for unemployment, then you have the appeals. I think the period to appeal is about 14 days. It's not very long, but you do have that option as well. And if you take a look at the next slide, I'm not going to go over this. This is available on the Texas Workforce Commission website for potential applicants who are interested in knowing what kind of benefits they can receive under pandemic assistance. It does break it down into the number of weeks, depending on what kind of assistance you qualify for and what you could potentially obtain. So let's talk a little bit about the stimulus check, and Andrea, feel free to jump in here as well. Just generally, the question that we've been getting a lot, and I know that Fane Justicia has been getting this question as well, is do I qualify for one of the stimulus checks? And unfortunately, most people, most of our clients are not going to qualify. If you are an immigrant, then you must have a valid social security number and a valid employment status. You must have the EAD. Having an I-10 is not going to be enough. We have several clients who we encourage them to pursue applying for an I-10 and to discontinue working with a false social security number. But unfortunately, in terms of the stimulus check, the I-10 is not going to be enough, as well as I'm sure most of you have seen the language that's come out saying if it's a mixed status household, if they filed jointly, where one spouse is documented and the other is not, then they're not going to be eligible. And the children who are obtaining those benefits also must have the valid social security number. Andrea, I don't know if you want to discuss a little bit about the substantial presence test.
No, I mean, there's details if folks are interested on like the IRS website. It's not an immigration test. It's actually a tax test. Don't want to get into so many of the details here, but on the mixed status household issue, you know, this is relevant if folks have already filed their taxes. If they haven't filed 2019, like they could file separately, but that could also affect, you know, what their returns look like. So there was a lawsuit filed at the end of April by MALDEF about mixed status families not getting stimulus checks. And I think we have a next slide that you guys will get to. We're not going to spend a lot of time on this. But if, you know, if your clients need these access to access these sites, they'll be on the PowerPoint.
And I would encourage those clients to talk to a tax professional if they have those types of questions. Unfortunately, I don't have that expertise, and I end up sending many of my clients to Baker Ripley or other organizations that do have tax professionals on staff. So I think we're going to switch gears. I know I gave a lot of information all at once up front, but hopefully the next few minutes will break it down a little bit more. Jessica, if you want to take it away.
Yeah, so I think that this next part of the presentation is going to be more of a conversation based on kind of calls that we have been getting through our centers, and I'm sure many of you guys have some sort of client or person that you guys are helping that has ran into some of these issues. So for example, at the Faithful CCL, we had a particular case where an employer who is now going back to work, now that establishments are opening back up, is now, unfortunately, she's getting their hours cut. And obviously that's not the first case that we've seen several cases like this. And then not only that, but due to the lack of business, her pay was also reduced. So in this question is, what can people do if their employers are cutting these hours and they're reducing these pays or even letting them go under COVID-19?
Sure, and you know, it's frustrating, I know, to talk to clients who are dealing with these challenges. Mm-hmm. And so if you all as service providers are encountering these types of issues, feel free to reach out to us and contact any of us here for more information. But generally, in terms of an employee's rights in the state of Texas, the biggest thing you have to remember is that Texas is an at-will state, which means that an employer, unless there's a written agreement somewhere, an employer can pretty much alter the terms of employment without notice. They have the right to reduce hours, cut wages, change positions. But the biggest thing to remember is that doesn't mean you don't have rights, and that doesn't mean that you can't at least obtain your wages for the hours that you've worked. So under the Fair Labor Standards Act, as well as the Texas Minimum Wage Act and the Texas Payday Act, your clients have rights. So no matter how many hours these individuals are working, they must, under federal law, be receiving at least the minimum wage for every hour worked. And that's going to be $7.25 for most workers, or $2.13 plus tips for tipped workers. And as well, if there are eligible employers, meaning they're making more than $500,000 a year in gross income, then any hours over 40 hours worked, the employee should also be receiving their overtime. If your employer is not paying you your minimum wage, you have a claim for unpaid wages, and there's multiple avenues to pursue remedies in that case. You can call the Wage and Hour Division at the Department of Labor and make a claim, or you can contact Fe and Justicia and have them assist you with a claim with the Texas Workforce Commission for those unpaid wages. If you have been let go or terminated, then under the Texas payday law, you must be paid within at least 6 calendar days or by the next paycheck period when you would have been paid. And if you don't get that final paycheck, again, you can contact the Wage and Hour Division at the Department of Labor, and we'll provide that information later on in the slide, or you can make a claim with the TWC. And as well, if that's happening, if you are encountering fewer hours, decreased wages, then if you have documentation, if you have a valid work permit, then you can apply for that unemployment insurance and the pandemic unemployment insurance with the Texas Workforce Commission. However, be aware, they're extremely backed up right now, and it's possible that you're not going to see that money for a long time, and it might even be really difficult to get a hold of someone to place a claim. Just an asterisk in all of that, if you've talked to someone who works for a large company where there are mass layoffs, those employees do have, under the WARN Act, right to notice. So they are supposed to receive notice if there is an impending layoff, which means it's going to be 50 or more workers laid off at one time or within a 30-day period. And if there are more than 100 employees at that company or at that organization, then that employer under the law must provide notice. And if they don't give the notice, then those laid off employees could be entitled to those wages for up to a 60-day period. So if you're talking to people and they're explaining to you, hey, this is happening to me, get a little bit more information, find out if it's just you, is it just you as an individual client, or are there many people? And that will give you a little bit of an idea of where to guide them.
Okay. And so for the next question is, can an employee be forced to use sick leave during COVID? We had one particular client who made a claim along with the rest of our coworkers that works at a large arts and crafts store chain, and they were forced to use their sick leave days during the time that the establishment was closed due to COVID-19. So is there any tips that we can give them, or what are the steps that they can take to go against this?
Sure. So there's a few different things that you can let them know. The first thing you want to pay attention to, I know we reviewed these at the beginning, and it gets confusing, and it took all of us with all the organizations we were working with several weeks to try to figure out what the CARES Act actually spelled out in terms of rights. But it's important to notice the difference that under the Emergency Paid Sick Leave Act, for taking time off because you or a family member are sick or experiencing symptoms, the employer is required to provide 10 days of job protected leave, and they cannot ask you to use any other type of leave before giving you these 10 days. Now, under the Emergency Family Medical Leave Expansion Act, which is the expansion of the FMLA, when you're using those 12 weeks of time to take care of a child or a family member whose school or daycare is closed as a result of COVID-19, those first 10 days can be unpaid. And you and your employer can discuss using other forms of leave to cover those 10 days, and your employer may even require you to do so. So just to know the difference as to what kind of leave you're entitled to, when it's permittable to ask an employee to use that time off. And if you're noticing a violation of any kind, then you can contact the Wage and Hour Division at the Department of Labor. Now, if you fall into the first category, which is the Emergency Paid Sick Leave Act, be aware that you do have several rights in that your employer cannot fire you, discipline you, or for both of those acts, really. Your employer can't fire you, discipline you, or retaliate against you for requesting or taking that paid leave. And if they do try to take action against you, contact the Wage and Hour Division immediately.
Okay, so as we are seeing that establishments are opening back up, obviously not to the full 100% capacity, there's a limit in that percentage. We have also dealt with a lot of clients who are in the service industry, particularly restaurants, who have complained because as these establishments are opening back up, their employers are not calling them back into work. And so they assume that this is like an unjust termination. So with this unjust termination during COVID-19, do they have a right to get rehired after this shutdown?
Right, and that's going to be a tricky answer. And the honest answer, unfortunately, is going to be it depends on the circumstances and it depends on the business. Again, remember that Texas is an at-will employment state, which means that an employer can fire or hire the employee of their choice for almost any reason except for discrimination. So if, for example, they're hiring back certain employees of a certain ethnicity, national origin, gender, and they're not hiring back others who are not in those groups or categories, there's a potential claim for discrimination there. So that's important to pay attention to as to, well, who's coming back? You know, are they all this national origin from this particular country and they're not hiring back immigrants from other countries? You know, what's going on here? However, if it's just generally, hey, we've been impacted and hit hard by COVID-19, then it's going to depend on what kind of leave that they've provided or allowed you to take as to whether or not your job is protected, whether you still have that job security. For example, if the employer is a small business, fewer than 25 employees, even under the current laws, there's not necessarily going to be a guarantee that an employee who was let go will be rehired because that position just may no longer exist anymore. They may not have the need and the company may not have the money to pay those workers. Now, here's some other situations. If the employee worked for a company with between 50 and 500 employees and they were let go or they're not being rehired because they had complained about safety conditions and concern about safety conditions, then they potentially have a retaliation claim under OSHA, and they could potentially seek their job back as part of an agreement if you file a claim. Or again, going back to the laws that we discussed, if the worker is forced to stay home to take care of a child, or because the worker or a family member has been exposed to COVID-19, then that worker is going to be protected under the statutes that we discussed. And another potential issue, and I know this is kind of complicated and each situation is going to be different, but if an individual could be rehired, but the employer is refusing to because it means that they have to provide them a reasonable accommodation due to a disability, then there's that employee potentially has a claim for disability discrimination under the EEOC or TWC. When you're talking to the clients and you're trying to figure out why they think they're not being rehired or why they think they may be able to go back to work or may not be able to go back to work, it's important that you pay attention to those details.
So we know that as COVID-19 testing came into play, particularly our audiences here at FEJ Justicia, and I'm sure at EJC with other organizations, most of the low income, the undocumented community, it was a little bit harder for them to get these resources, right? And so when it came down to going back to work, a lot of the employers were asking for these employees to get tested and come back with actual proof that they are not, they have not tested positive. Can an employer actually do this? Do they have the right to ask the employee to get COVID tested before returning to work?
Well, the short answer, yes. COVID-19 has been designated as a pandemic, which gives a little bit broader leeway to employers and the types of questions they can ask and the types of things they can ask of employees. They are permitted to take an employee's temperature. They're permitted to ask an employee if they've been having COVID-like symptoms, or if there's reasonable belief that there has been a COVID-19 exposure, that person seek medical attention and get tested. But that medical information at the end of the day is confidential, should only be shared with medical personnel such as the Department of Health if there's a positive COVID diagnosis. It should not be shared with coworkers. If an employee is worried that, oh, well, my employer is going to go blabbing to everyone and tell them that I was potentially exposed, they can't do that, and they can seek relief. It's important that the clients that you're speaking with know that they do have a right to their medical privacy and confidentiality.
What are a person's rights if they fear retaliation? There has been workers who have made claims with other organizations like OSHA, for example, in regards of safety and health violations, lack of masks, lack of PPE. What are their rights in these situations?
Right. So there's different forms of protection against retaliation. And the biggest thing you want to know is, what's the basis? Why is this individual afraid of retaliation? And what are their immediate concerns? If it is that they're fearing retaliation for complaining about a lack of safe working conditions and they have contacted OSHA, then they do have rights to seek a claim for OSHA retaliation. Excuse me. Where they can file a claim with OSHA again and say, hey, I made a report to you all. It was supposed to be confidential. My employer found out about it, or potentially could find out about it, and I think they are going to fire me or take action against me. And they do have that protection under the law to file a claim for OSHA retaliation. If you're dealing with someone who's worried that there might be retaliation for refusing to return to work, maybe they're afraid that there might be an unsafe condition, or they're afraid someone has been exposed to COVID-19 and they don't want to risk it. That's going to be a different type of issue that you're going to be asking about and talking about. If they're afraid about going back to work, like we said, Texas is an at-will state, which means that if they don't come to work, the employer could potentially fire them unless they've expressed concern that they or a family member has an underlying health condition that puts them at risk. So the best option in that case is, under the NLRA, is to talk to other coworkers and come together and ask for safety measures to be put in place, and ask as a group. Because under the NLRA, your employer can't lawfully discharge you, discipline you, or threaten you for engaging collectively as a group to discuss advocating for safer work conditions. And if they do try, then you would actually have a claim for retaliation under the NLRA. The last potential issue that I know some of our clients deal with is, I'm afraid to make a complaint. You know, my hours got cut, I'm not making a lot of money. My employer's telling me they're not going to pay me, and if I complain about it, they're telling me they're going to call ICE. Well, unfortunately, if the employee is undocumented, there's always going to be a risk, especially if you're dealing with an employer who has a habit or a history of taking advantage of its employees and not paying them or not treating them well, of lying or cheating, such as not paying the minimum wage, not paying overtime, harassing the employees, discrimination, abuse. There's always going to be a risk that an employer will actually take action. It's illegal for an employer to do so and to retaliate against a worker for advocating for his or her rights under the law, but there's very little disciplinary action available for an employer who actually follows through with their threats. And if a threat has been made, the best course of action is to contact an attorney for next steps.
Okay. So as the days go by, obviously there's a lot of need for financial assistance. There's a lot of need for any sort of relief. And most of our clients obviously have an ITN number, and they have asked us if they could qualify for unemployment with this ITN number. Or a lot of them ask, like, what happens if a worker is using another social security number? Can they also apply for these benefits as well?
And my immediate response, and the response of any care worker or individual who's counseling these clients, is to tell them no. Only a valid authorized Social Security number can be used to apply for unemployment insurance benefits. And if you are a non-citizen, if you are a documented immigrant with a valid EAD, they are going to be asking you for your alien registration number, your A number, during the application process for those benefits. So if you don't have an A number, if you don't have a Social Security number, please do not apply for unemployment benefits. If you're using a false Social Security number that is not yours, or have borrowed one from a friend, doesn't matter. They will only accept valid authorized Social Security numbers for that process.
Okay. And can an employer force anybody to return to work, even if they're not providing the sufficient protection? We had one case particularly where the coworkers had kind of been talking amongst themselves, and they shared information that they had tested positive, and their employer was still forcing everybody to go into work if they did not show any physical symptoms, if they were still feeling just fine. The employer was advising that they return to work, if not they were to get fired. So what kind of protection do they have in those scenarios?
So that is also going to be a little bit complicated based on the situation and the scenario. Remind these clients that under the law, they are protected under the Families First Coronavirus Response Act and the CARES Act, meaning that even if they are undocumented, they do have rights to that emergency paid sick leave and the Emergency Family Medical Leave Expansion Act. If the employer is refusing to provide them that leave, they can file a claim with the Wage and Hour Division of the Department of Labor. But if it's just fear that, oh, I heard someone potentially had a positive COVID-19 result, I'm afraid to go back, I'm not really sure if I'll be put in danger. If it's general fear, unfortunately, you have to go back to that at-will policy. An employer can fire you if you're refusing to return to work, even if it's just because you don't feel safe. You have to at least demonstrate that you've asked them for a reasonable accommodation because you or a family member is at a health risk, which means potential exposure could be life-threatening for you. Or if you've requested leave, like I mentioned, under the statutes. And there are going to be some statutory exceptions. So if you have requested a reasonable accommodation for a disability and the employer has at least 15 employees, then your employer can't fire you or discriminate against you for making that request. And if you don't have a disability or you haven't made a request for reasonable accommodation and you do attempt to take that emergency paid leave, you can discuss that with your employer to try to delay your return. But at the end of the day, if you don't have any of those options available, your best option is to continue showing up to work. And if the workplace feels unsafe, talk to your coworkers, come together and ask collectively for improvements for safety. And if you're talking about an individual who's come to you and said, I have tested positive for COVID-19 and my employer is still forcing me to come to work, that's a different issue. And so they should immediately take that paid leave, request it, and if they're refused, immediately go to the Department of Labor and potentially even make an OSHA complaint for safety issues. And so if you want to take a look, I have here provided, this is directly from the Occupational Safety and Health Administration's website. So under the Act, or the Occupational Safety and Health Act, you're entitled to a safe workplace under the law. And you have the right to speak up about fear of a lack of safety in your workplace without fear of retaliation. And so I definitely encourage anyone watching today to take a few minutes, go to the website, and kind of familiarize yourself with what the law indicates and what the workers' rights are. And if an individual believes their working conditions are unsafe or that an employer has violated a standard in safety or health, you can file a complaint. Those complaints are anonymous, as well as the complaint for retaliation. So I encourage you, we have really good relationships with some of our local OSHA representatives here in Houston, and we can provide you that contact information if you encounter someone who needs to make a complaint.
And this one is a little bit more towards Andrea. Does accepting the benefits during COVID-19, like unemployment and these disaster relief funds, does it affect the ability to become an LPR, or will it be deemed as a public charge?
Yeah, so for those of you who have been on the past webinars, we've talked a lot about public charge. I'm not going to get into too much detail about public charge itself, except to say that this is a test that comes up when someone is trying to become a lawful permanent, adjust their status through USCIS, or in some cases when they're coming in from outside the country and they're applying before the State Department. And so folks who are consular processing to become lawful permanent residents will do that through the State Department. For folks who are trying to go before USCIS, this is a forward-looking test. It is looking at several factors. So just because someone has taken certain public benefits does not automatically make them a public charge. You're at 5 different factors, including age, education, income, as well as other factors. And so this isn't, it's not automatic, as I said, and it's also forward-looking. So if someone is on public benefits for a short time in order to help them get up out of poverty, and then, you know, they're going to be in a different situation a few years from now, like that person has to keep that in mind too. Also have to keep in mind that someone's situation may change. They may not be eligible for public charge, and so they may not be thinking about it today, but tomorrow they meet someone and get married to a US citizen, say, and now perhaps they're eligible to adjust, and now they have to be thinking about it. So that's why public charge can be a little bit tricky. But in terms of, even when people are applying for permanent residence and are subject to this public charge test, there are many exceptions. So for like asylees, refugees, special immigrants, juveniles, and many others. So keep that in mind as well. And if you guys have questions specific to public charge, I'm happy to answer them. In terms of which benefits are considered, you know, the USCIS officials will consider cash assistance for income maintenance as money. So the stimulus money will not be counted, but it does, because that's a tax refund, but it does not consider disaster relief under the Stafford Act. And so the COVID-19 pandemic has a disaster under the Stafford Act on March 13th. So, you know, it's completely excluded. So any local fund, for instance, that's assisting under, you know, because of the pandemic is not going to be considered. Similarly, if folks are, you know, on a public benefit for a short time because it's like they're getting on food stamps in order to help their family because they've lost their job, well, they would just have to include evidence that they've lost their job because of social distancing or because of the pandemic. And this is showing that it's short term, right? So in that long view of whether or not someone's a public charge, it's a short term, you're including evidence and you're moving forward. Just because you're on food stamps for this does not mean you're going to be a public charge. And then in terms of unemployment insurance, it is not considered a public charge determination when someone's applying for lawful permanent resident status. So there are a lot, you know, it's for the most part, it's not going to be an issue, broadly speaking. And again, if folks are want to get into more details about public charge, let us know and we can share a lot of resources. The Protecting Immigrant Families campaign is a really great resource. So if you don't get those emails or haven't checked out their website, that's a great place to go.
Are there local resources if you don't qualify for this federal aid?
Yeah, so HILSC has compiled a resource guide, which is a living document. It's a Google Doc, which with this link, you will have access to make suggestions. So if you have a question, put your question in. If you have an answer, even better, put an answer into someone else's question. If something's changed, make a note, because the HILSC staff, while this is something that we're working on, we don't have the time to be able to look over everything every single time. It's as up to date as the community makes it. So if you're in that document, please help to continue to help it become as up to date as possible. Other local resources, many of you may have heard that the Harris County Commissioners passed a $30 million fund that has no immigration restrictions, and that's being passed through the Great Community Foundation, which will give it to several nonprofits. There are several nonprofits within the HILSC network that have received that funding or have sought other funding on their own to be able to offer this. And you can find out all about those through our accesshou.org website. And in a moment, I'll kind of give you a sense of what that looks like and how to use that website. Another resource is the Immigrant Rights Hotline. Hopefully this is not the first time you guys have heard about it. The phone number 1-833-468-4664. It's answered Monday through Friday from 9 to 5 by 3 great hotline operators from Boat People SOS, United We Dream, and Baker Ripley. And they are able to answer questions about news. So for instance, like the DACA decision that might come down some Monday in June, folks can call them and they'll have access to information about that to share with callers, as well as referrals. So if someone needs referrals for financial assistance, they'll go on to accesshou.org. I'll show you what they do in order to share that information with callers. Way to get access to those local funds is to call 211. They are sending folks, and a lot of organizations that have that $30 million funding must take a referral from 211, at least until that money. So that's another place to send folks. And then when you get this, you'll have a link to a NILC document that just really helpfully explains what the CARES Act is and what types of immigrant statuses qualify for what relief under there. So quickly looking at accesshou.org, if you guys have not looked at it before. This is, sort of on the same path as the COVID-19 living document, right? All of our systems at HILSC are democratized and only made better by you. So we kind of create we hold the space, and we hope and expect that you as partners will put in your data to improve that system. So here, for instance, if you type in COVID, and then you would click on financial assistance, say, you'll get a list. Right now there's 72 results. One of them is Fe Justicia Worker Center. And so you would click on the fund and there's information here, and you would click it again. I don't have that next slide, but then it pulls up even more information if there are any restrictions. And Fe Justicia can go in and edit it. So you can edit it in this drop-down menu. Oops, sorry, I don't actually have this done, but if you drop down in the edit menu, or if you're in here, you will see help complete this profile at the very top. So let's say Jessica's on here and she's like, no, you've got our website wrong or something. She goes in there and she makes the edit. And typically the Access to Services Committee vets all of this information to make sure that there's no errors in it. That's why when you put in the information, it might not automatically appear. But right now we're in disaster mode. We recognize that people as quickly as possible under COVID. And so things are going to go on as soon as they're posted. And if there's any errors, like those are still being screened as we go, but it's pretty automatic. And so I urge you all to check to make sure that your organization's resources are on there, and to make use of the resources that are existing in our community, because they're, it's not infinite, but we do have more than folks sometimes think. And Jordan in her presentation referred to the Department of Labor, the Texas Workforce Commission, and OSHA as resources. And so these are some of those websites. And as she mentioned, you will be getting this PowerPoint along with a link to the recording in your emails, so you'll be able to access those. Finally, I wanted to share the contact information for Faith Justicia Workers Center and Equal Justice Center. These are both great resources for your clients, right? I mean, just because you're doing health work or immigration, legal services, or refugee services, you know, in order to be a holistic services provider, you might hear something and you're going to want to act on it. And so you can make these referrals. If you ever have questions, feel free to reach out to us as HILSC folks. We can help connect you to resources like these. But ultimately, you know, we're not the ones doing the work. People like Jordan, people like Jessica, they're the ones on the ground with the expertise who can help your clients. So we've got about 6 minutes if you guys have more questions. I know we have 3 questions right now. Go to our Q&A. Lovely slide for you guys to view. I'm going to stop the share just so that it's like a little more convivial in a gallery view mode. But one of our questions is kind of going back to the pandemic unemployment. If someone is denied for regular unemployment insurance, is there something, and they're trying to get the pandemic unemployment insurance, what can an advocate do? What does that advocate need to do once that first denial comes in to make sure that they can get the pandemic unemployment? Oh, sorry, yeah.
Unmuted. Okay. As an answer to that question, the first thing I would do as an advocate is pay attention to deadlines, because pay attention to deadlines, because when it comes to appealing a decision, sometimes you have only 2 weeks, 14 calendar days, and you want to make sure that you know exactly when the individual got denied and when their response is due. Make sure that you're keeping track of addresses, making sure all the addresses that they used in their application is valid and up to date and current. Because in all honesty, at the end of the day, it's going to be about making sure that you're applying, that the applications are going in on time, and as well as any appeals processes. I would pay attention to the Texas Workforce Commission website. They have information on best suggested times and dates for when people should be calling to try to get a hold of someone. Like I mentioned earlier, unfortunately, they are very backed up. Many hundreds of thousands of people, I think at this point, who have applied for assistance throughout the state and throughout the country are still waiting on that money. So keep trying, keep encouraging the client to not give up. Keep calling, keep calling, keep calling. They have the hours listed. I think they're even accepting calls and applications on Sundays and weekends. So just keep encouraging them to not give up if you really think that they're eligible for those benefits.
Thank you. Another question is, what if a person uses the amended FMLA provision? Can they also file for unemployment insurance?
My initial answer is yes. Obviously, it will be a case-by-case basis, but generally, if they're using the amended FMLA provision, even if they are getting paid, it's at a reduced rate, and that reduced rate is based on what type of pay they were receiving, whether they were salary or hourly. So they're obviously, and either way, they're not making what they would have been making. And so the unemployment insurance, specifically the pandemic unemployment insurance, is supposed to help counter that loss in wages. So initially I would say yes, unless you think unless there's the possibility that they shouldn't be using the FMLA and leave anymore, and they should be returning to work, which I think is addressed in one of the next questions that we can talk about.
Yeah, the next question is that some people's work hours were reduced and they are getting the $600 supplement, but now they're being asked to go back to work full. And what are their options? And I don't know, Jessica, if you guys have seen this too from folks at Faith Justicia Workers Center.
Yeah, this is a case that we have been we've been getting a couple of calls. Within ourselves, most of the folks that we work with either have no status or a mixed status family. So our initial answer obviously would be like we would have to go through those requirements first before we're able to give them a solid answer. But I know there's other organizations where their main audience does have legal status. So I don't know if that's something that you want to talk about, Jordan.
Right, because if they're undocumented, they're not going to get unemployment insurance. So they're not going to have that $600 supplement.
Yeah.
Well, for workers who are encountering that situation, if they are being asked to come back to work full time and they're coming back to the same or similar salary, then you're going to look at, well, are they able to return to work full time, or are they still caring for a child or family member who is ill or whose schools have been closed? And that will determine whether or not they can still stay at home. And whether they can stay on unemployment benefits or not. But like we mentioned, if there's no valid reason for them not to return to work, then they most likely should, and it means that their benefits are probably going to end.
So it's a valid reason, like I'm afraid that I'm going to get COVID-19, and so I would rather not work and stay home. I don't have anyone to take care of. I don't have any underlying health conditions. My employer is providing, a mask, maybe gloves. But is that if I decline to go to work, can I still get my unemployment benefits?
Most likely in that case, I would say no. And again, it's a case-by-case basis. We would have to evaluate. But if there's nothing preventing them, and if they don't have a COVID-19 related reason to stay at home to care for themselves or to care for someone else, then most likely they would be denied continued coverage under the pandemic unemployment assistance.
Okay, I see we have one more question, and we do have, and I think that both Jordan, Jessica, and I could stay on for a few more minutes, but I want to respect everyone's time and give folks who don't want to stay on to listen to another couple Q&As the opportunity to. We want to thank you all so much for joining us. Please feel free to reach out to me, Andrea. I'm at houstonimmigration.org. On our website, houstonimmigration.org, you can find the info to contact me directly if you have suggestions for other webinars you'd like us to do. As I said, on our website, we have a general overview on the houstonimmigration.org website, and we'll have the housing webinar and this webinar up soon, probably within the next week or so. And I will be sending around to the listserv the information on the food and nutrition webinar that's happening later this month. Again, many thanks to Jordan, many thanks to Jessica, and for those of you who are staying on, go on to the next question, I think, if that's all right. And for those of you who have to sign off, do sign off here. Great weekend. So Libby asks if there's any risk that the $600 from the federal government could be considered a public benefit for purposes of public charge, since it isn't regular unemployment. I don't think so. I don't have an exact answer to that. I think the answer is no. I don't know if anyone on the chat has a definitive answer. I think that I've seen it on the on the Protecting Immigrant Families campaign, that it's not. I mean, it is still unemployment, even though it's not regular unemployment, but it is unemployment, and unemployment is not considered. But I can do some very quick research just to double check that I'm not wrong. If anyone else has a question. And
I would agree. I'm not as familiar with the statutes and regulations concerning public charge, but my initial belief would be that no, because even though it's not regular unemployment, it is part of this expanded pandemic unemployment assistance. And so my initial suspicion is that there's going to be a little bit more leniency there.
And I just shared into the chat the link to the Protecting Immigrant Families Immigrant Eligibility for Public Programs During COVID. Sorry, it's on my second screen. And so they've got a thing about unemployment insurance, and it says that it is not considered public charge, and it includes that $600.
I think we may have lost Andrea for a second with some internet cutout. I do see an additional question. I'm not sure that I have the wherewithal to answer this because it does seem like it's
no.
All right, are you there? Can we hear you? Or can you hear?
Yeah, is it better? It says my internet connection's unstable, so I'm going to go off of video for a sec so you can hear me. But the next question is if there's any help in terms of federal stimulus money for dependents that no longer live with their families. So these would be people who filed as dependents in their taxes last year. If it's a 2018, you know, if they haven't filed their 2019 taxes yet, and they can still do so until July. So if the college student over 17 is going to file their own taxes this year in July 2019, then they would be able to. Again, that college student would have to have a social security number, have a lawful immigration status in order to qualify. You don't have to have filed taxes in order to get. There's other ways to request it, and that is on the PowerPoint. I will quickly put it into the chat as well. But here's some of that information from the slide that I'm going to paste into the chat for folks. But if you're not required to file a tax form, then there's that link, irs.gov, which is, I'll do it again. I feel like that was a lot of info that I accidentally pasted. So the link is there. Other questions? Okay. Looks like that was it. I hope that you all enjoyed it. For those of you who were on the employment webinar, the housing webinar, you'll note that we're kind of trying out this new Q&A format to make it a little bit more engaging so that you don't just hear someone drone on and on in a presentation, since Zoom calls are already so overwhelming. If you have any feedback for us, please feel free to send me a private message. We always are looking to improve the way we get information to you, and we are all ears. There is another question about private contractors that don't have status, if they would apply for PUA.
So the short answer is yes, they could qualify for the pandemic unemployment insurance. I think if you are an independent contractor, you have a few more qualifying issues and hurdles that you have to cross. And I don't recall what they are, but my initial answer is yes, they can, but I think they have to show a minimum amount that they've made in the last year or last 6 to 12 months, something in that capacity. But yes, normally they would not be eligible. Under pandemic, they are.
Okay. Well, thank you all so much. I'm going to leave it there. I'm going to, Jessica, I don't know if you were getting ready to say something. Okay. So again, thank you all so much. If you have any follow-up questions, Jessica and Jordan both share the contact info for Fe Justicia and Equal Justice Center. So please reach out to them, reach out to us. Thank you all so much for joining us. Have a great weekend. Take care of yourselves. Thank you, Jordan.
Thanks.
See you soon.
Bye.
Bye. Bye, everyone.